I think once I start seeing this, we are live. I've done this now 38 times. You'd think I'd have this down, but I'm not that smart. Welcome back, everybody. This is Beard Banter episode 38. I'm stoked because this meeting has been meant to happen for like a year now for Brad and I to have a chat. So this is probably one of the happier moments for me on Beard Banter recently. Sorry to anybody else last couple weeks. I didn't mean that way. But, you know, Brad, great to have you here, man. Why don't you introduce yourself?
Really good to be here.
And let people know who you are. Tell me a little bit about yourself, man.
Great. So first of all, it is a highlight of my year, month, I don't know, week, whatever it is, to chat with you because, you know, we've talked about this for a long time and you're one of the most respected in the industry. So really not blowing smoke. I'm going to begin by that. So really happy to be here. So a little bit about me. Who am I? So I'm an attorney that represents technology solution providers nationwide, globally, actually, but for the, I guess, viewers here nationwide. Started out on this thing right here on my TRS-80 Model 1 Level 2 16K, which, by the way, I still have the user manual for.
Throw it in the chat if you've ever owned a trash 80. I'm sorry, TRS-80.
No, you could say trash 80. That's what everyone calls it, a trash 80. So that's fine. I defended it as a kid. I was like, yeah, it's trash 80, but what do you have?
What do you have? My $3,000 desktop. Yeah,
exactly. It out on a TRS-80 at the age of 11, programming DOS and then assembly language, compiling it, and so on. Turned into a teenage hacker to the extent that you could be a hacker back in, 1983, 84 or so.
You could definitely be a freaker in those times, though. You could definitely,
and that's what it was.
At that stage.
It was all about phone freaking, and it was all about creating the boxes that you held up to payphones so they simulated
my blue
the sound
box,
of the
my red
in.
box, my black box. Yeah, I'm with you.
That's totally. It. I buy 2600, the quarterly, the magazine. I figure out how to do it. And then here's the funny thing. So we'd go to, my friends and I, we'd build these boxes. We'd go to payphones. For those of you who are under the age of 30, a payphone is a phone. You have to explain
it. Put a quarter in or a dime probably at that time, right?
That's right.
Also, the coinage of drop the dime on you as a methodology.
That's it. So, that's exactly right. So we would go to these payphones and we would hold the box up and we would, simulate sound of quarters going in. So now we have like $3 in credit, which back then you could call, China for $3 in credit. But here's the thing. As an 11-year-old or a 12-year-old, we didn't have anyone to call. We didn't know who to go. We had all this credit, and we're like, "Who should we call?" We'll call Mike.
I'm rich.
Mike lives down the block, right? It's like, what are you going to do with all this power, right? So we would just like call local restaurants, and then
that's so
order
good.
stuff and hang up, and that was our big event. And then as time went on, we'd hack into like local utilities that didn't guard their admin pages, and
so this would be like 2013 then. Sorry, I digress.
Exactly. Some pipelines that we'd hack into, and the whole concept was that first of all, we were working off a 300 baud modem at the time. That's how we started out, a 300 baud modem. So you could type faster than this modem could pull up information.
Sure,
but that's how that's where it started. It started as my friends and I hacking into software using bit duplicators to copy software games for the Commodore 64.
Go download a key. The cracks that you'd get, cracks.net was huge, right? Like back then. But anyways, I ran a BBS later in those years. So in the early 90s.
So you know all about this.
Yeah. And what was funny, I'm definitely past the statute of limitations on this. So I'm good talking about it. I'll ask my attorney.
We all are.
But yeah, I used to reprint AOL CDs and crack AOL accounts because AOL had a flaw that if you could get into the account, it would use your stored credit card to pay for anything you might want to buy. And they would give you a pop-up and say, hey, you want a new US Robotics 2400? You want a new 56,000? And so I would refresh all my BBS modems by just cracking accounts and getting them shipped to a PO box. So that's how I kept my 6 lines up to the
We weren't that sophisticated. We just figured out at a young age that, like, for example, some of the software on floppy disks, the way they protected it was they would physically damage one of the sectors on the disk. And so if you tried to copy it, it didn't work. But if you loaded it, it would skip over that sector. So we developed code that would skip over the sector and copy the rest of it. Yeah, we had a lot of fun.
That's cool. See, I wasn't that nerdy. We got separate vectors of nerdiness in that regard at that time.
When you're a kid and you're wearing the glasses, right, and you have the big hair and all, then it's a nerdy.
It's already
now
ready
they're
for
calling you kind of cool, right?
Yeah. Now you get paid well and wear hackers hoodies, know, at school.
Exactly. Yeah. You speak at conferences and you have sliced up hard drives hanging on
Yeah,
your wall. So there you go.
exactly. Yeah, it's
That's what it
winning
is.
right here.
Yeah. So from there, I ended up going to law school because medical school I decided I didn't want anymore
Sure.
to
But was
pursue.
that your
So
initial thought? Was that side
that
of it
was it.
initially was
Yeah,
doctor?
I
Yeah.
was a bio major. I took all the bio and the chem and the
Oh,
calc and
goodness.
the physics, and then said, I don't want to do this.
Well, those
So
have direct applicability over to no, they don't. Those
oh
are all
yeah, I use it all the time when I throw something. When
I
I'm
use diff
frustrated with my
equations to
phone.
check the jury out. Yeah.
No, when I'm frustrated on my phone, I'm going to throw it against the wall. I can figure out the acceleration of
Yeah,
how
and how close
hard
it'll get
it's
to the
going to hit
wall before it actually touches, right? Yeah.
before I have to pay $800 for a new phone. So I worked in the DA's office in Nassau County, and I was given back then, because I was the computer nerd,
Sure.
what was the first case of computer harassment in the nation. And what it was involved a woman who had broken up with a boyfriend, and he went on a BBS, or actually many BBSs, and put up, for a good time, call so and so,
Yeah,
used
totally.
obviously more flowery language.
I've been disappointed so many times by those ads. Anyways, I digress. But
you just can't trust. You can't trust the bathroom wall
on the internet.
anymore.
It's crazy.
Who can you trust?
I digress.
So she was getting all these calls.
Yeah.
She called the cops. The cops showed up. They had no idea what to do.
Oh,
They
no.
called the guy up, and he admitted it. He's like, yeah, I did it. So,
Right.
and they're sitting there. Everyone's like, what do we do? So they arrest him and they charge him with harassment.
Sure.
We went to trial. He was found guilty. He paid, I think,
set a
$50.
precedent, right?
Yes. Well, start a precedent of you can't say for a good time, call this person.
Yeah.
And he walked out the door paying $50. But that was sort of the light bulb moment in my career where I said, I could take law and I could take computers and put them together and do some stuff, right? Do some things
It's
here.
new law that I can actually help drive, right?
It.
Essentially.
And around that time, that's when forensics started to come into play. Hard drives were being seized and so forth. And the detectives would have them
care of evidence challenges that are new, that have never been thought about. How do we
preserve this evidence? Exactly. How do we keep it? How do we store it? How do we even explain it to the court? So they're not going to dismiss this case just because they don't understand it. So that was how I started, as a prosecutor in New York and then down in Miami. Okay. I founded the Internet and Computer Crime Division of the State Attorney's Office.
Oh, that's
and then
awesome.
moved into private practice because, at the end of the day, while being a government attorney, a prosecutor was still, to this day, the best job I ever had. Best job I ever had. It doesn't exactly pay all the bills, unfortunately. Yeah. So we move into private practice in about 2000, and here we are.
So let's touch a couple things for anybody watching right now or catching up with us down the road. So there's a couple terms I want to talk about. One of them is in the Anglican sense of law, which rules most of the United States. And I also have an attorney here, so you can correct me where I'm wrong. But in the Anglican sense of this, it's all a precedence driven. You're going to definitely have laws, you have governing things, but it's really the applicability of those laws, especially around stuff like a new technology like this or medical or whatever it may be, applying that precedent and creating court data that can be used in another brief somewhere else saying, here's why I think I'm right because of this precedent set before. So that's a term that people need to understand, especially around taking a law like, let's say the False Claims Act, and we'll dig into this a little more, that was kind of written in 1860s, back before we even had any thoughts of computers or any applicability of these things. Right. And so that work, to your point earlier of, I found like could make a difference or make change in this, applying this, right? That's what that work is, right? It's taking existing laws or new laws and applying to them as technology that people don't understand, which brings us to the second part. And it's a term called prosecutorial challenge. And it's also a term in this understanding, as I understand it, of if I can't even explain it to people, how in the hell am I ever going to get the court to take this serious? How the hell am I ever going to get this through a process that they've got to spend money to take up time on a court's case to move forward with this, right? So am I missing anything on those two, or you care to explain or expand?
No, you're exactly right. So our law comes down, like you said, from hundreds and hundreds of years ago, and it evolves over time. And as we come up with new technologies like railroads, like cars, like computers, I mean, think of the technology evolution that we undertake here. We try to either shoehorn old law into new technology, or we have to create new technologies, new laws rather, altogether. Right. So, for example, we under privacy, let's say data privacy, there really wasn't anything solid or codified in the US until 96 when HIPAA came out. Why? Because we realized, oh, some of this medical data is actually being stored on these things called computers.
That's it,
Computers, right?
Those hard drivey things behind you, right?
And they're stored on hard drives, right?
Yeah,
and people misuse that stuff, right?
You're kidding me. People will take advantage of a situation and make profit under crime. This is blowing my mind, Brad Gross.
This is crazy. But in 96, I mean, we're going back 30 years here. This was, it was understood, but not fully understood. So they created a new law. Okay. And they went with that law until they realized in around 2010, that law had to be, redone. So they come out with the High-Tech Act that amends HIPAA. And so sometimes we try to shoehorn things. Sometimes we create new laws, but you're 100% right about precedents. Everything depends on precedents. And if precedents hasn't been set, then it opens the doors for experts to come in and say, well, this is what it should be from this point forward.
Exactly.
Okay. Yeah. And as far as prosecutorial, explaining to juries and to judges and so forth, making it easily digestible, it's an art, not a science. It really did. And that's why you have now whole units, which they didn't have when I was there. I started one,
right,
whose sole job it was to become the Rosetta Stone of what the technology is and what it can do and what it shows. And then you have the juries who barely understand how to use back then their Casio smartwatch.
Right.
And,
right.
Try to be the Rosetta Stone and translate it. Or the Palm Pilot. Right. Or the BlackBerry, which I still think was a good device, by the way.
My friend Matt Topper, that's been on this show, used a BlackBerry until 2020, I think 2021. There was an Android flavor
like the Betamax. It's like the Betamax of video recorders, right? Betamax was a clearly superior standard,
and yet it lost, unfortunately.
And it lost. I mean, go figure. But we digress. So you are 100% right. You have the challenges that we've had over the years in the legal arena are applying old law to new technologies, and of course, explaining what is to people who don't understand that type of thing. Those have been the challenges for sure.
You led me straight into this, Brad. It's almost like we rehearsed it, which we don't. This is always just
which
chat,
we did not.
Yeah. So this
are those your sneakers behind you?
Yeah, dude. These are
those? I mean, I'm hate to interrupt, but I'm looking at those sneakers. Are those yours?
Yeah, I got these. I got them from a vendor that took me to a Nike factory, and then they had a street artist there to paint my logo on it. It was so dope. It was one of the best experiences I've had. It was so cool.
I like it. I've just seen those sneakers. I meant to ask you off camera.
Anyway, I've worn them on stage once, and then they rubbed off a little, so now they stay here on the desk forever. But
I like it.
But
so what did I lead you into?
So you led me into this understanding that I feel like civil law is playing out faster than legislative bodies of law that are creating this, right? And I'll give you an example. So I was Fred Levin's banker. So when I was a private banker, I handled his accounts, and he had money in that people just think are stupid. Like I wouldn't leave $7 million in a checking account, but some people have that kind of money. They don't care, and that's their play money. But my point is, he was part of the legal team that started that whole Philip Morris aspect, and took and said, "Hey, you as a company knew you were killing humans." Knew you were doing this to children, and I'm obviously massively summarizing the challenge from the legal perspective. But the point is, you look at this where I think you'll see watershed legal cases. I might have used that term wrong, but around cyber where a civil suit says, hey, Rackspace, you killed 100 people in a hospital because you chose to be insecure first. Right. And so you're already seeing it right after the Rackspace piece. There's like 5 civil lawsuits that are class action suits that have already started.
Sure.
What do you think that landscape does if you fast forward a couple of years? Does civil continue to shape this faster than legislative or law-based?
For sure. Look, I'll tell you, I'll draw an analogy. It sounds strange, but it's accurate. I was convinced that what was driving websites and software, and especially intellectual property law in the area of computers and coding, was actually porn sites and gambling sites. Those sites, right? Those sites drove more innovation to not only the coding itself, but the law involving coding and what is
interesting
and so on, right? You'd say porn sites, porn sites, because they were protecting their images, they were protecting their names, their trademarks, and so on. So, as far as drawing now an analogy to this, I think that Yeah, I think that civil law and cybersecurity and so forth is going to be the driving force to make changes to all kinds of computer and infrastructure related laws, for sure. Yeah, it's going to
including
lead the way,
precedent, right? And setting this
including precedent.
litigious capability out of precedents that exists. And,
Yeah. I mean,
you know,
look,
yeah.
back about now, what, 7, 8 years ago, maybe more. No, now, goodness,
Doesn't it
years sort
suck
of
feeling
passed.
old, bro? I mean, you do have a
Oh my
TRS-80 sitting
god.
behind you, so, like, I
Wait,
just wanna
who are
codify
you
that.
again? Where am I? Where am I? All right.
I have that feeling every morning.
So you know, Yahoo experienced a lot of security breaches back in 2010-ish, 11-ish,
Sure.
and so on. And then they said they fixed it. And then they experienced another one. And then they said they fixed it. And they actually were sued in a series of cases up until about 2016-ish or so. It's called In Re Yahoo. And their argument was, okay, after they'd been sued, after they had been after it had been shown that their cybersecurity stunk for their email capabilities and that it was always vulnerable and they knew about it, their big defense was, wait a minute, you know what? This whole case should be dropped against us. This class action should be dropped against us because all of our users sign a terms of service.
Oh,
Right?
you're
And
bringing me right around to this week's
and
announcement,
so,
Brad.
see, right
Jeez.
there. So, and they sign the terms of service, and the service term, the terms there say that we're not liable for anything. And if we are liable for something, our damage limit is so
Limited.
low. I
Yeah,
mean, it's so low. It's like literally, I mean, it's a few bucks, right?
Yeah.
So they really can't even, there's no damage, right? There's no damage. Even if they prove their case, what we have to pay out is so limited, this whole thing should be dismissed. And what the court said,
You
no, we're
can't
not
limit
dismissing
negligence.
well, they said they went even farther. They went even
Okay.
farther. And what they said was, they said, we are not going to dismiss this case against you. And here's why. Even though the terms of service definitely limited damages,
Sure.
The service you're providing, email, to all of these millions of people is so important, so vital. And you knew it had a defect. You knew it, right? We're not going to actually allow you to, it would be unconscionable for us to allow you to enforce this section of your EULA, essentially.
Is that a little bit of ruling from the bench, though? Is that a little of legislating from the bench? I mean, a smidge.
You know, unconscionability is always a little bit of ruling from the bench because it's a fact-sensitive thing.
Sure.
But, you know, if you sat back and you thought about it and you said, well, it's one thing if Yahoo, and I'm, you know, picking on Yahoo here because they were in the,
let's call them Schmahoo. I like to use a different term. It really helps.
Schmahoo with a question mark. Schmahoo,
yeah.
question mark.
It's Schmahoo question mark.
Schmahoo.
Yeah, you have to sound confused as you say
if it was an accident, if they first discovered it, and then they said, look, you know, we're trying our best to fix this. When you offer a service to the masses like we do, there's going to be a few broken eggs here, and that's why we limit our damage. Then I would say you're ruling from the bench if you say, well, we're going to let it move forward. But in Yahoo's case, Schmahoo's case, it was year after year. I mean, it was every 2 or 3 years.
You proved patterns. Right.
It was a pattern. And at that point, the court said, no, it's unconscionable. I feel a little bit better about that, for sure.
Yeah. What's interesting is it touches on reasonableness, right? And when you start getting into those facts of that unconscionability, or even in this understanding of like gross negligence or negligence in general, you start looking at reasonableness. And I think what's interesting is when you have such a fact-heavy thing to argue over, it's really about who tells the best story, right? Yeah. And especially as an attorney trying to win this in a more kinetic way in a court, right? And so when you think about that, it means that if I said as an MSP, why did you choose SentinelOne? Man, because it's that new hotness, bro. It's great. Everybody's buying it. My friends are using it. It's so good. Compared to, why are you using SentinelOne? Well, I started following a control family with my clients, and one of those controls said that 10.1 and 10.2 described that I needed an EDR product. 10.3 and 4 went on to define that I was using that. You don't have to educate. It's reasonable. You can tell that story to a set of jurors without them understanding the technology underpinning it, right? And that's this argument I've been making. And so I'm putting that forward for you to kick around, kick to death, or whatever. But I like to think of it as this term of MSP's job is not to protect their clients. Their job is to be able to do it in a way that's reasonable, that shows that they had due care met, that they can dot and show as they grew and learned, it changed. If Yahoo or Schmahoo was able to demonstrate that from number 1 to number 2 event, They increased posture, they changed, they understood the new TTPs, they put in new restrictions, they changed their EULA to be more inclusive of these things. That's a story that takes away some of that unconscionability and says, man, you just keep getting punched, brother. That sucks. I hate seeing you get punched like that, as opposed to you're the cause.
But it shows they're acting reasonable, that what they're doing is tied to the cost of implementation and the whole thing. I mean, they could go on, and you're right. They would probably have been a lot better off. And it comes down to the story that you're telling, for sure.
Yeah. And so that's one concept I've been kicking around, from an MSP's perspective around this changing legal landscape is you really just need to make sure you're always telling the story. Right. And that then leads you into backing
into. What do you mean by you're telling the story to whom? Your customer, if you're an MSP?
No. Some of this is authoring history, right? Some of this is, why do you advise people to get that in writing for some reason? Why do you advise people, right? It's some of that same thing. And so when I take that tactically, what I mean is every half year I have a review of my stack, and I actually ask my customers or my partners this, and then I check for this. And this year we added 4 new things that we're checking. So what I mean by that is like matriculating and writing down history in a way that it could be proven. And that if I handed that over for discovery to somebody else, they're going to come to the same conclusion of, this is a healthy company that's actually caring about their customers and is definitely fighting these challenges. And it's one of those where even being transparent about the challenges when documenting and saying, had these conversations, customers are generally not okay with this. I'm going to have to make a decision to turn it on anyway, and I'm going to lose. Like, that tells a story to a jury of an improvement.
I think you're right. And I think that a lot of companies fear the documentation process, because if they move in a different direction, suddenly they feel like, oh, well, what we had documented in the past showed we weren't going in the right direction.
Right.
So we either have to get rid of those records or not keep them whatsoever. And in my view, I'm more in line with what you're saying, which is show an evolution. Show that you've put some thought and care. I understand that what worked on day 1 might not work the same way in day 475, right? Or day 800. I get it.
Yeah.
But I agree with you. Documenting workflows, documenting needs and vulnerabilities that you're then addressing and so on is definitely the way to go. It's definitely the way to go to show responsibility. I teach a class to LLM students. Advanced
What's
law
LLM?
Students.
I'm sorry.
LLM. Now
people in the law profession.
Well, an LLM is an advanced degree beyond a JD. So it would be like the next highest. It would be like a specialty. But what LLM stands for? Now
I don't necessarily need that, but
thing of what it means.
But what's interesting about this is a lot of people are afraid just to be wrong and don't even ask those questions and nod and go, "I got you. I know LLM, no problem."
Oh,
and
no,
anybody listening, I want to
JD is Juris Doctor. What does LLM stand for? I'm not exactly
sure.
Let's
find out. I'm going to do it. You go. You keep going, and
I promise you, someone's Googling it already. So the name of the course is corporate cybersecurity responsibilities. Okay?
It's Legume Magister, so it's Latin for a master of laws. So it's
I knew it was some sort of Latin thing. We're still using Latin,
and it's a little aggrandizing too as its statement, but that's okay. We'll
for sure.
Off. Yeah, so
for sure.
But you're teaching these masters, which means you're a master.
I'm
teacher.
Teaching these masters.
Yeah.
Master teacher, yes. And this is not the podcast you thought you were doing.
Yeah, totally.
Right. And one of the things that I talk about all the time is documentation, and not to be scared of being wrong. To be scared of being wrong. Understanding that if you're going to get into cybersecurity and you're going to get into the technology industry, you're in an industry that's constantly changing, constantly evolving, and there's nothing wrong with saying what we did a year ago actually won't work today.
Yeah,
that's okay, as long as you move forward and say, well, we're going to change it up. So it falls in line with what you're saying.
Here's why that's so powerful too. If you take this back to what actually makes dollars, moving to your point of going in private practice, right? Making profit. Mm-hmm. When you start thinking about that transparency and humility of this world changes, law is constantly changing, technology is constantly changing. I'm going to keep you up to date as this changes. I'll be your person. I'll be your guide. I'll drive you through that. That's better than going, Matt, why are you changing from this to Sentinel-1? Because it changes. Right? So that's the point you're setting in stone. So when you're bringing that back and showing that delta is there and there's going to be stuff that works today that won't work tomorrow, threat actors change, I'll stay on top of it. That's why I hire my attorney. I don't have the time nor the knowledge to dig through precedent and know where I can push and where I can't. And a lot of those things that were learned in tradecraft, they weren't learned in law school.
Agreed.
Yeah,
And that's why people hire Pac Satan. That's why they have people like you on staff, because they know that you're on top of this stuff, so they don't have to be on top of it. Of
and
course.
trying to make it easier for them and more digestible and democratized and all of those same things that you're attempting to do in law from that same practice, right? So I think that this understanding of documenting the history, being humble and transparent, showing that you can learn from it. One of the best compliments I ever got was a guy named Benno van Weyenberg. He's a Belgian. He was one of our engineers, and he's brilliant. But he often, in my opinion, let perfect be the enemy of good, in the sense that he was always looking for that perfect answer, and oftentimes that meant you'd miss that good one in the forest for the trees, right?
Yep.
But one of the compliments, we got in fights early, and one of the compliments he gave me, I don't know if he meant it to be a compliment, but he did say this. He said, "Matt, I've learned something about you." I said, "What's that?" He said, "You hold extremely loosely to passionate beliefs." And I think that's kind of what you have to be in cybersecurity or even in the rule of law, of saying, I might believe this completely passionately, but once that court sums in here and says that's not true, or once something changes in the body of understanding in cyber, I need to be flexible enough to let new data influence my position, so I can just as loudly scream that now new and true statement, if that makes sense.
Not only does it make sense, that's a perfect litigator mentality. The extremely passionate, right? But to understand that, maybe it's going in a different direction, then become passionate about something else.
Right.
He was 100% right. Where is he today, by the way? Is he not with us?
He's brilliant. No, he's brilliant. He moved to Belgium. He was an internal tech for an MSP we merged with, and he started his own company. And he has a baby and has moved on with his family life in that way. But I asked that same question. In fact, I think maybe Tony Miller or Nick Nyberg are on here. And if you are, I'd love to hear where old Benno's, what he's doing these days. But
what he's up to.
Yeah,
so
but
we dovetailed into what happened last week. Right?
Yeah, we did.
And so forth.
EULAs. Great, bringing us back on point, man. I'm gonna have to double your salary on this one. I'm actually getting the better end of the deal, because I know your hourly rate is not cheap, and I'm getting a whole hour with you. So this is like counseling, lawyer talk, all in one session.
Okay, I'm billing Wes Spencer. It's fine. We'll keep talking. Wherever you are, Wes.
Perfect. He's right. Good. You're Wes. You can write the check in dictator coin if you need to. But so let's talk about this. So Jen Easterly, as Johnny foreshadowing the day before the Natty Stratty, which is what I'm calling it. Everybody hates it, but that's my jam. But the National Cybersecurity Strategy that came out, both of those kind of poked out, saying it's not okay for you to EULA away shitty practices on technology.
Well, at least they implied it.
Yeah, definitely applied it. And then with the national strategy, it's definitely one of those pillars of that public-private cooperation. It has both sides of that, and it's a finishing of the 2 years ago in 2021. DOJ stood on stage in October and said, "Hey, we're going to start prosecuting under the False Claims Act civil lawsuits with a whistleblower clause." And then they did one, right? They sued Aerojet Rocketdyne, and since then, and then now they're even talking about applying that to HIPAA. So you could see this kind of conversation saying this one premise, and I've had this said to me many times, Brad. I've had executives look me in the face and say, "Matt, a lot of really good money is made on really shitty software." Right? That's a legitimate statement of why there's not reinvestment in that software, why the capitalization ROI is coming from that software's acquisition, with no intention to fix it. This is the schmahoo conversation. This is we know there's a systemic and endemic problem, and we are not fixing it.
And we're going to build other platforms and other software on top of that.
Oh yeah,
right?
Yeah, and make this an underpinning vulnerability, right?
It's not just that the software itself or the solution has problems. Then you build part 2 of the solution on top of part 1, and now you have a foundational problem, right?
Yeah,
a significant problem.
So Alex Farling's with us. Good to see you. Also, Kevin McCarty. So awesome to see you here, buddy. If you're here, chat in. I will pop the chats up. I just leave this down for the porn bots and those other technical advances that are coming against YouTube. But yeah, go ahead.
I'll tell you. I think that I agree with you that Jen Easterly and the report certainly implied. They didn't come right out and say, this is what we're going to do. We're going to start passing legislation that says you can't EULA your way out of liability. And I think there are good reasons for that, because which we could get into.
I've signed the red lines, right? I've been involved in some of those contract negotiations where I'm spending $5 million, and I have a literal limit of liability down to the dollars I spent, with way more impact than the dollars I even spent, right? In the $40 million range for the risk.
For sure.
So
I mean, the problem with that, though, and I'm not saying that, look, theoretically, I get it. I understand that you have these big companies that have crappy solutions, like you just said, and then they build on top of the crappy solution. So now they have a crappier and more brittle solution. And when it all fails, the company turns around and says, but look, we had a EULA. I get it. I get the problem. I really do. Now, that said, if we're going to flip that coin over, I would challenge people to think about what, if you're a company, if you're creating software and you don't want to have company ending liability because everything has holes in it. Everything has holes. Every house that you've lived in has holes in it, right? Everything has holes in it. And you don't want to have company ending liability. Well, what do? I mean, do you just simply say, screw it, we'll keep doing it until we're sued out of existence? Well, no, we'll limit our liability. Well, the government says you can't.
Yeah.
Well, and then the question is, do we limit liability in certain industries, right? If you're making ball bearings for an airplane wheel, maybe that limitation buried in a EULA should be different than if you're making caps on for a water bottle design software or something that, it might leak, but then everyone gets wet. Okay. So it's a very difficult situation. It's tough to, the report, to its credit, did say it should be industry specific. And I agree with that.
Well, let's take this. I like analogies. That's how I make things make sense to me, right? I make frameworks and compare them. So if you think about this, going back to the Miami collapse of that condo, right, that happened last year, and you look into that exactly, and you get into that legal challenge there of building was built to code at some point potentially, but there was code. We could actually define what good looks like. In some ways, for that building, we could say, here's what good looks like. But there's also places where you can find negligence in its application. And a great example would be they had a pool, and that pool was designed afterwards that created a leak, that created concrete going away, that created the hole punch failure that existed on that concrete, or the shear punch failure. Yeah. And so when you think about that, you get into some interesting places where we as a software industry don't have that corollary. There isn't a good software design law that sets you need to have studs on 16-inch center, and you need to have a shear punch resistance to this much, and you need to have right. So there's not even anything to go back and say, yeah, but I followed those rules. I did build that software accordingly. I had but we're starting to see that. That's where these applicable frameworks, like the stuff that's coming out of CSA for STAR, some of the things around software design that are coming from Jim Manico and team at OWASP, and other things that are out there. I think that's a big gap in our world, right? Is that to your point, you couldn't just say, all right, here's the, what do they define it as? The safe harbor that you're going to be able to do. Well, what do you safe harbor against? What do you set as that standard? It's now just reasonableness.
Yeah. And it comes down to, and that's why I think that, the concept that you mentioned earlier, and you mentioned
is funny. I don't mean to cut in, but Heath goes, one of those industries is responsible for Betamax losing. So nice tie back, Heath. I love it.
Well played, sir. Well played.
All right, sorry. Back
because I maintain the Betamax was better technology. So I think this goes back into or dovetails into the concept that you brought up, not just today, but in the past on other venues, the SRO. Right.
Yeah.
The SRO is, I think, one of the ways that we can start to address a industry specific baseline model, industry specific
that's fast changing.
That's
right. Like law or medicine or CPAs from AICPA or any of those bodies. Right. Good call out. So thanks for bringing me back to center on that point. Yeah. So one of the challenges I find with our industry is that anyone can just take out a sticky note, write MSP on it or MSSP or googly doddly walker or whatever you want to call it for technology. And there is no defined standard, right? I joke about this, but my hairdresser, when we went to do our beard charity, so anybody that's watching doesn't know this, we shaved our beards, me and 16 people for $200,000. Yes, right. You got a coin. You're a proud owner of one of these. So
that's exactly it. Yep.
So there's only 100 of those, but so the point is when I shaved my beard, we were looking to have you or highest bidders be able to just like do it themselves. Like we could make that part of the fun. You can't. In the state of Florida, you must be a licensed barber in order to do that in a public venue and be in a situation like that. That's the way it worked out. We went to the attorneys on it, right? And so this was the interesting part.
What kind of an attorney knows that? By the way, it was your attorney. What kind of attorney?
You know what?
We want to shave our beards.
Topic for another conversation.
Call?
Let's find the expert. He's done 90 of these beard cases. He's the barber's nemesis.
Now that's a niche. That's a niche. I thought I had a niche. That's a niche. All right, go on. I'm sorry. You were saying
a very hairy situation often in court.
wow.
But I digress. But yeah, oh man, you actually did it. You successfully got me off my topic. So the point is, there's regulation. You have to go to a board of cosmetology. You have to go to school for 6 weeks. You have to apprentice. You have to prove you can cut hair, and it's going to grow back. But in our world, we do this, and it may not. And I think there's always been this case of technology always outpaces the law structure that protects it, right? Like ultimately, it was those porn sites fighting over ownership that created a precedent that then separated this new technology of owning data in the cloud, if you will, kind of to that
exactly
point.
Right.
And so as us, though, Mary said beard attorney, as us, though, we don't have that. We have no barrier to entry. And the challenge is if you try to just regulate our industry through traditional legislative methodologies, either national or state level, I don't think you're going to be successful because you would simply just get rid of an MSP. I would just hire an internal person to be the idiot and the schmuck that does it. And great, we're still in the same boat we were in.
Exactly right. You've just supplanted one for the other.
Yeah. So I think the answer comes in FINRA. So for you saying SRO, for anybody that doesn't know, we're talking about a self-regulatory organization where you have approval from Congress or approval in some form from state or other legislative bodies to regulate an industry, right? To be the board of cosmetology, to be the ADA, to be the AMA, to be the bar association, to set standards inside an organization of fast-moving data and body of knowledge. So that said, in a doctor, you can't just be a doctor working for a company. You have to be a doctor first by the AMA. Now you can go work in a hospital, you can be in private practice, and those come with different things. But in FINRA, when I had my Series 7, so I had my Series 7 stockbroker's license when I was 19. And in FINRA, the concept of SRO said two things. Matt, you must have a license and show you've got the body of knowledge. Gotcha. Check. Cool. You must also be appointed to work at a broker-dealer. And if so, at that broker-dealer, you are now active, you're appointed, they will handle compliance, they will be there to tell on you when you're doing something wrong for poor Mary that you're stealing or blind, right? They're there to be that check, and I'm there to be that balance. If they're doing unsafe practices, if they're doing things that are wrong, if they're cheating the compliance system, I am required by my license to tell on them. And it gets even more interesting that to take this into what would a normal company do, I can also be an RIA, which means I can be a registered investment advisor and take on those actions myself and have my own compliance team. Still have to be audited, but I'm kind of like a broker-dealer, but I'm myself. The reason I bring all that up is you're looking at the same framework that could be applied to the MSP space, where if you're an MSP, you're now a broker-dealer. You have a bunch of licensed brokers or technicians or people that work for you that touch tech, and you'd have to define what that looks like and where is the tech touch point, where it's not. But as you license that out, then you now have this concept of what if I'm a tech and I want to go work for a private company that's not a MSP or a service provider? I still have the responsibility to maintain my license to do certain baseline things. And if they ask me not to do them, I have to separate or I have to tell on them in a whistleblower fashion. So when you get into this world, an SRO could be any business over X revenue in certain verticals must have these things in play. And you don't destroy a market because of that. You, in fact, lift that market up by driving, barriers to entry to some extent that make us better. But unpack that. I just went through a billion thoughts there, but help me out. And
I think that. So, all right. So unpacking it, I think you're right. I think that the MSP industry, we're going to start at the beginning, is an unregulated industry. And anybody who says, oh, no, they're regulated, look at the laws like in Louisiana. And so, no, they're not regulated. Those
they're
laws
just counting them. They're registering them. Yeah.
That's all it is. It's a registration law that says, by the way, if you're hacked, you have to tell the state agency that you're working for. Oh, same thing with is that registered? Right? So now we're regulated? No, that's called common sense. Right. So we're not regulated. It's not a regulated industry. And anyone who tells you differently is probably, I don't know, selling you something. So that's first. Second,
that's a whole other bag of worms.
Tell you what it is. We're going to call it as we see it. So then the question is, you're right. If it's an unregulated industry, how do we bring some order to this? How do we bring some function, some order, and make it so that we're not undermining the industry, but at the same time providing some guidance, some direction, something, right? So not everyone could just hang on a shingle outside their door that says, Brad Gross MSP. Well, I know how to back stuff up, so I'm managing that service. I'm an MSP. Okay. We need to bring some order, some structure, some standards. And along those lines, SROs, which, you're right. They are private organizations that usually work with a public entity, a public function of the government, like FINRA works with the SEC, that create the standards, that create the rules, that create the policies, and people want to be part of the SRO. Either they want to be because they're incentivized to, right? It's like the good housekeeping seal of approval, right? You want that on your product. Well, you want to be part of the SRO because consumers are looking for it, or you're forced to do it, right? You're forced to do it, like your example, like my example, the bar. Right? If I want to practice law in Florida, I have to be part of the Florida Bar Association. That's what it is. It's not just the Florida Bar; it's the Florida Bar Association. It's actually a company. It's a company, okay, that is under the auspices of Florida Supreme Court. But the idea is that it's a public-private gathering.
You might say a partnership, like described in a recent national security strategy. Interesting. You might say that,
like something that we might have heard from last year and last week. And I think that that's what it's going to be. That's going to be the key. And if you're going to say, well, what applies for the security industry doesn't necessarily apply for all industries of managed services, right? That's why it's industry specific. It can be industry specific, it could be service specific, it could be function specific, but I think that that's the key. I think that's where we have to go for sure.
And I think you have to approach it in a way that grows over time, right? And here's what my strategy has been. So with this national strategy change, it actually gives me a lot of hope. But the way I've always approached it is this: find a program that can be that organization, that has the financial wherewithal, that has the public trust, that has the capability for the testing requirements, that has the capability for the matriculation and management of the licensure aspect, that already does all that. And then get them enough density of certain people participating at a baseline that you then can define that baseline as the baseline, right? So you grow it and then approach Congress and say, we've already got something going. Let's make this better. Let's build it. Let's make it bigger. I didn't have a company for that until recently, but I think CompTIA is developing Trustmark. I've been working with Chris Johnson on this, and what's coming out of Trustmark is a damn good standard for at least an MSP service provider that is providing and has administrative access to their clients' worlds, right? And bringing that in and seeing those, if you could get enough people doing it for the first reason you mentioned, which is it's valuable to customers, we're going to put in marketing dollars to show why it makes sense, we're going to answer why it's a security tie-in, sure, but at the same time building for option two, and option two being at some point you'll do it because you have to do it. Right, you're regulatorily required to do it. That's why Board of Cosmetology has every person wanting to cut hair has to run through those hallowed halls at some point in almost every state, right? And so I think that's the stratagem, and we're really running close to out of time. But my push has been we haven't had a framework good enough for this. We haven't had enough mass and critical density, and not to get into even all the insurance and subrogable risks and all the other things that are driving this world forward. I think a CompTIA or someone like them has the opportunity to be the SRO build of that organization.
And it has the experts behind it. I'm part of the CompTIA family as well. I'm in their cybersecurity council. They have the experts on hand to get this thing done.
Exactly.
I agree with you.
And to set a fast-moving set of standards, because I think that's the whole point of this is if I talked about MSPs and what it took to protect yourself 4 years ago, we would never have been talking about supply chain risk in the same way. We'd have never been talking about the tools themselves and the risks of them. The SSO infrastructure wouldn't have been decided as anything from a regulatory reason or any type of framework reason. I just did it because I thought it made sense. So I think we're getting at the same point of this industry is going to change fast. We need a body that can change fast that's made up of its members, right? That's why attorneys serve on the bar. That's why people do that piece, is to bring that knowledge base back, to teach the LLMs, right, if you will, for your service there. But anyways, I think this has been a fun jaunt through this conversation. We're wrapping up the hour. So if you could tell MSPs just one thing about what's changing in their world, what should they be looking at? It can be anything you dream of. I don't care.
What's changing in the MSP world? I think that what is changing in the MSP world is increasing customer reliance on MSPs. I think that MSPs are becoming more and more ubiquitous. So reliance on them is increasing exponentially. And along those lines, I think the key that MSPs need to do, okay, until there are SROs and until we have regulated things and set up protocols and baselines, until that happens, what every MSP has to do is manage a customer's expectations. Explain to the customer what they do, what they cannot do, what their limits are,
what I've legally said I'm to do, what I'm not to do, right?
Right. That same point. You have to manage the expectations, because the most vicious and expensive battles and the most the stuff that really gives MSPs a bad name always involves a mismanaged expectation. Always. Yep. And so, if I were to tell MSPs anything, I would say explain. Don't assume that the dental office that you're doing, work for, or the construction industry that you're working for, understands what XDR is compared to EDR with a different solution that we're going to offer from a Huntress or SentinelOne, or pick your vendor. That's not. You have to explain it. You have to explain the limits and the parameters. If you do that, that's a huge step to avoiding liability, avoiding problems, avoiding lawyers.
Yeah. That's a great point. And I think that's actually more of a life lesson than anything, right? I think it's better to talk about the uncomfortable, or to talk about the limits before it becomes even more uncomfortable. And human nature tries not to do that typically.
Right.
So,
because, they think customers just assume that you have it all covered. And by the way, they're advertising that way, MSPs. We have it covered. Stop.
Yeah, literally. There's an MSP called All Covered, right? Like literally.
We have another hour because we'll get into advertising.
Yeah. We get into that for the next. Maybe we have a part 2. In fact, I would love to have a part 2 about some of these histrionic marketing claims. And like, you couldn't do that in the auto industry. You couldn't say nobody will ever die in this car. Bullshit. I'll hit it with a big old semi truck, right? Like,
and the Federal Trade Commission is going to get involved in this stuff as well.
Gosh, you're pulling my string, Brad Gross. This is part 2. We're gonna have to come back.
Part 2.
Everybody, thanks for being here today. I really appreciate you. It's awesome to see everybody. I'd love to see more in the chat, more poking fun at us if you can. I have to assume we just wowed you so much there was nothing to chat about. But love y'all. Appreciate it. Brad, this has been awesome. I thank you for being here.
You got it, Matt. I'll see you soon.